Good morning, everyone, and thank you so much for your attendance. Also, we'd like to give a special thank you to those who had submitted their questions ahead of time. If we do have time through this webinar, we would like to be able to address some questions that you may have. My name is Becky Page, and I am the president of Human Resources Plus, and along with Teresa Friel, who's our senior HRP professional. So as most of you know, at HRP, we're really committed to providing quality and affordable HR resources and guidance, and especially trying to help with compliance guidance that really will help you reduce your liability. As always, we're pleased to have Jennifer Gokenbach as a co-presenter. Her top-rated firm, the Workplace Council, has represented many employers from many industries. Also, Teresa and I, Jennifer, would like to just publicly say we so appreciate your support and collaboration over the last 14 months. We couldn't have done it without you. Also, I'd like to take a moment to recognize all business owners, operators, managers. You know, I've tried during this process to kind of explain for me what it has been like as a small business owner to my family and friends. And of course, I rattle on about the stress and what tenacity and ingenuity it took, and the cash flow worries, employee worries, on and on and on. And I notice I just get kind of a blank stare. And I do realize it's like having a baby. You can't tell someone what it's like, but until you really have one, you don't know. But I know everyone on this call understands that we are unique. We're in this together, and our contributions are more valuable than many will ever know. We're so appreciative for all of you. It's a little exciting. At HRP, we're working on some concepts to create more of an interactive and supportive community for all of you. In order to accomplish this, we will not be holding a webinar in July and August, but we will definitely be back in September. So stay tuned. Just the regular housekeeping items. You've all been muted. During the question and answer, we may ask you to unmute yourself. You will always, as always, receive the PowerPoint presentation and the recording. You can ask the questions in the chat window. And as always, the big disclaimer that this is the information contained in the presentation is not to be considered or provided legal advice. So our agenda today is over kind of the big four things that we've had going on during the last year. The first one is we're going to have Q&As on the Healthy Family and Workplaces Act. Then we're going to talk about the Equal Pay for Equal Work Act. And then the Colorado Overtime and Minimum Pay Standards. That's the one that is the acronym of COMPS, COVID-19. And then we have some just general HR questions. So I'm going to turn it over to Jennifer. She's going to do the most complicated is the HFWA.
Thanks, Becky. And it's been my pleasure to work with you and Teresa and to be presenting these webinars that you all have organized and put on for the last number of months. And so I appreciate being part of this process. So yes, I'm going to just recap a little bit about the Healthy Families and Workplaces Act that is in effect here in Colorado. As a recap, it requires covered employers to provide up to 48 hours of paid sick leave to qualified employees, either full-time or part-time. And if it's part-time, then it's going to be on a prorated accrual basis, depending on how written policies are written, if you have them. The Act also requires up to 80 hours of public health emergency leave in the event that there is a declaration of a public health emergency by the governor. And we're currently still in a public health emergency. So employers that are covered need to be aware that they may need to provide up to 80 hours of paid leave if it's a condition that is required to be provided that paid leave. Effective, so there was a rolling basis of the Healthy Families and Workplaces Act of when it became effective. So as of January 1 this year, the act was effective for employers with 16 or more employees. And then effective January 1 of next year, it's going to be applicable to employers of all sizes. So a question that came up was, when will the public health emergency declaration end? We don't know exactly. I heard estimates maybe August, maybe the end of the year. But the latest Colorado executive order that was issued in May extended the public health emergency for an additional 30 days. So, you know, it's still kind of a TBD situation in terms of our Colorado government when they are going to declare the health emergency to be over. So stay tuned on that. Important for employers to know is that the Healthy Families and Workplaces Act, even if a public emergency is deemed to be over, the paid leave can still be utilized for up to 4 weeks after the end of the emergency. So keep that in mind. And then, you know, we're aware of Colorado being a state that is getting vaccinated at good rates. So it looks like 46% of Colorado is fully vaccinated. And I believe the Denver metro area might be even in the 70% range. So those are bright spots and good news. Another question that has come up is there anything we as employers need to do to close the loop on the FFCRA or the PHE payments that were made in 2020 or 2020 and 2021? So basically what employers should ensure they do is that they have well-documented records of the paid leave that was offered to and used by employees. So offered to would mean essentially if any notices were sent out, if any updates were made to policies or handbooks, make sure that those are maintained. And then of course, have good records of any paid leave that was utilized by employees, as well as how it was accrued. If you have records that are, you know, published on pay stubs, or if those are just internal records of maintaining accruals, just make sure those are maintained. For the FFCRA tax credits, so that's the federal tax credits, employers will report their total qualified leave wages on their federal employment tax returns. And so that's something that employers should consult with finance or accounting or CPA to make sure that that gets properly reported on the tax returns. The HFWA in Colorado does not have any specific reporting requirements, but as is typical for all of our labor and employment laws, employers do need to just have accurate record keeping systems in case they get audited by the state or an employee complaint comes in. And there are a couple of resources that folks can access that are available online. If you're looking for guidance about the FFCRA tax credits, there is information on irs.gov. There is the actual link is irs.gov/newsroom/how to claim the credits. And all those words are separated by dashes, or you can just do a Google search, but there's available resources online. So another question that has come up for the Healthy Families and Workplaces Act is it the employee's responsibility to claim paid leave benefits that companies are accruing for them? Or should the employer question the reason for every absence? For example, have employees sign a form every time they take a half hour off work. And then likewise, if they don't want to use the HFWA leave at first, can they change their mind and ask to use it later in the year? So under the HFWA, it is the employee's responsibility to request the paid leave under that act. So basically, it's the employee's responsibility to provide enough information to the employer for the employer to recognize that this paid leave is triggered. How that's done is according to the wage protection rules that were promulgated by the Colorado Department of Labor. Those rules, specifically Rule 3.5.5 states, an employee may request leave orally or in writing, including electronically, for example, by email or text message. An employer can choose additional methods of receiving requests or notifications that it deems acceptable, but shall not restrict employees from using any method that notifies the employer effectively. So in response to the question about whether an employer can ask employees to sign a request form, that is fine. For record keeping purposes, it is acceptable. The only issue is the employer can't require the completion of a request form before they use the leave or as a condition for using the leave. So basically, you know, as we've seen with how this law has come into effect and the various rules and regulations that the Department of Labor has published and promulgated, there just can't be an impediment to an employee taking the leave. So while you can have a form be signed and that can be your policy and procedure, you can't condition the leave on completing that. Having a written policy in an employee handbook that lists the qualifying reasons for the HFWA leave could be a good way to prevent employees asking a lot of questions or about the leave, as well as it could prevent the employer from tripping up on asking too many detailed questions about medical issues. So if you have a handbook policy, for example, that lists the qualifying reasons for HFWA leave, then the employer can just ask the employee, okay, is your leave covered by a qualifying reason under our sick leave policy? So that opens the door to the employee requesting the leave without the employer getting too much information, too much medical information or whatnot that might open the door to other issues like the ADA or other things like that. Also, the law says that employees must make a good faith effort to provide advance notice of needed leave. So if an employee has a qualifying reason for time out of work, as an employer, you know, you can encourage the use of HFWA leave and discourage employees from banking it to use later. So, you know, basically you want to have a policy or you want to have communication to employees that explains to them, like, we need advance notice if practicable and possible. And if there is a qualifying reason, then we want you to use the HFWA leave rather than, you know, banking it to use later, which is often something that employees like to do. It's human nature. So in any event, the next question is, at the end of a year, if an employee has unused HFWA paid leave hours accrued, I understand they can carry them forward. Is the max accrual balance the available HFWA paid leave hours per year at any point in time 48 hours? In other words, if they carry forward 48 hours to 2022, will they no longer accrue additional hours until they've used some of these hours? Then once they use some hours, do they start accruing hours again until they reach the 48? So this is not completely clear, or we'll say it's clear as mud, I guess. So basically the law says that up to 48 hours of the HFWA can be carried over to the next year. So just keep that 48 hours in mind of that, unless you have a different policy, but the law says 48 hours can be carried over. So, and employees can only use 48 hours within any single benefit year. So basically how this could play out in a circumstance of perhaps where somebody doesn't ever take the paid leave, and you're wondering, how do I record this? How do I track this? Because now there maybe time is going to come for them to use it. So for example, in 2021, say an employee accrues 48 hours of sick leave and they don't use any. So then that 48 hours carries forward into 2022. So now, hypothetically, you're in 2022, a new benefit year. The employee has their carryover balance and they accrue an additional 48 hours per the law. Theoretically, right? They're allowed to accrue up to 48 hours per year. So in November of 2022, they fall ill and they need time out of work. So they use the 48 hours that they are allowed to use per calendar year. Do they have any remaining hours to carry over into the next benefit year, 2023? And so what our best interpretation is, unless we have clearer guidance from the Colorado Department of Labor, is that the 48 hours that they theoretically accrued in 2022 would carry over to 2023. So basically in 2023, this hypothetical, the employee should start the year off with 48 hours. And then that accrual would also continue theoretically. So this is a unique circumstance of somebody who hasn't taken any paid leave and then they need to take it at the end of a benefit year. This question of, well, if they use all of the 48 hours they're allotted for that year, do I have to carry any over to the next year? And so in short, our recommendation is yes, you should carry over the max 48 that they're allotted. So again, if we get further guidance from the Colorado Department of Labor on that, it can help clarify this issue, but that's our thoughts for now.
Great. Thanks, Jennifer. So I'm wondering if anybody has any additional questions. We may be able to take one or two, depending on the length, for the Healthy Families Workplaces Act. If everybody's good on that, we can always come back to it. We're going to move on to,
hey, Becky.
Yeah.
So we did get a question in regards to whether or not Colorado will be reimbursing employers for the paid HFWA.
Okay.
And obviously the answer to that is that, the employers are responsible for financing the 48 hours of paid leave. And really the only, as Jennifer talked about, the possible tax credit would be for the PHE leave, and that would be more on a federal level and not on a state level.
You mean for the FFCRA?
For the PHE leave, for the COVID leave, and not the HFWA 48 hours of paid sick leave.
Okay.
Does that make sense?
Yep.
Okay.
Okay, we're going on to equal pay for equal work. I really want to stress that this law, you really, some point, all businesses really need to focus on this law. This is of course a personal perception, but I think once this kind of gets out and about among employees, and a lot of times employees will get online and, law obviously, as we know, is very hard to interpret. but I can really see employees challenging this particular law. So this law has two parts. One prohibits wage discrimination based on sex, which includes gender identity alone or with any other protected class. As you know, in the state of Colorado, we have, up to like 15, 20 protected classes easy. So, and then the second part is requires transparency in pay and opportunities for promotion and advancement. This is probably the biggest change for all of us private employers, as far as the requirements that they want to, requirements that they want us to post pay in job postings and things like that. So one of the first questions we've seen is, we see a lot of job postings. We all go on Indeed on all these Colorado employers, and they're not including compensation, which under the equal pay for equal work, no matter where you're posting the job, internally or externally, you do have to include a compensation or a compensation range and a general overview of benefits. What we've discovered is many employers are still unaware of this law, or they're really kind of struggling to understand and implement the provisions. But the compensation posting requirement does apply to all Colorado employers, and it includes companies based outside of Colorado who employ Colorado residents. I would assume those are the people that are going to be the slowest to kind of get up on speed as far as what the requirement is posting in Colorado. The next question we had is, we went to offer a promotion to an employee, and we get this one several times, and we know that the only internal candidate has the qualifications needed for the role. Do we still have to post the job internally to all employees? I'm going to give you an answer in kind of a roundabout way. So under the act that states that employers must make reasonable efforts to announce, post, or otherwise make known all opportunities for promotion to all current employees on the same calendar day and prior to making a promotion decision. And they go on to define what a promotional opportunity is. A promotional opportunity exists when an employer has or anticipates a vacancy in an existing or new position that may be considered a promotion for one or more employees in terms of compensation, benefits, status, duties, or access to further advancement. So in essence, the answer is employers, and this is on, we have great links on the prior screen. It's called Info 9. They're called interpretive, they used to be called fact sheets, if you guys remember, but now the DOL has changed them to what's called interpretive sheets. It says, employers must notify all employees for whom a vacant position would be a promotion, and they may not limit notice to those it deems qualified for the position. Employers may state that applicants are open to only those with certain qualifications, and they may screen or reject candidates based on such qualifications. So in essence, the answer is yes. All right, does anybody have any other particular questions about equal pay for equal work? This is pretty much the ones we have as the requirements of, posting. The big thing is everybody at Shump, I know everybody's busy, but at some point you really need to kind of look at your compensation and do a compensation audit. The farther you go as far as developing a compensation philosophy and plan is going to protect you more. And, I would assume most people's largest expense is in their labor cost. And I can tell you the compensation plans we've done, every client is just very surprised once it's all put in a good little package to notice, the differences of people in different positions and the different pay. So now we're going to move on to Colorado overtime and minimum pay standards. This is the COMPS order. Effective January 1st, there's, of course, it went into effect last year, but it's back to number 37. So next year will be 38. It covers minimum wage, exempt salary, overtime, meal and rest periods, time worked, complaint and anti-retaliation rights. It also covers uniforms. We've heard that a prospective client has already been challenged by an employee for that particular part of this law. So once again, employees are becoming educated on the laws that we need to administer internally. The break one is really tough because it's very specific in the law. I'm sure you've all read it, tried to put it in your handbook. The question is, my employee wants to skip their meal break or use their break at the beginning or end of their shift to arrive late or early. Is this allowed? Now, this was very common in obviously the restaurant industry, at least when I worked in the restaurant industry. And in essence, the COMPS order, and I kind of like Jennifer's input on this, requires employers to provide an unpaid, uninterrupted, duty-free meal for shifts over 5 hours, okay? Then they go on to say, to the extent practical, meal periods must be at least 1 hour after starting and 1 hour before ending shifts. It is generally inadvisable, our guidance is to allow employees to skip their meal period or to use it at the beginning or the end of the shift on a regular basis. So, there may be exceptions that you allow them to do this on an infrequent basis, but it's really advisable to have the employee sign some sort of statement that is their preference to skip or alter their break period from regular expectations. We did have another question come in after this PowerPoint was done about if somebody works an 11-hour shift, do you have to give them 2 1-hour meal periods? When we called the Department of Labor, we actually got 2 different answers because we always call the Department of Labor twice. The most conservative answer is yes, and provide a second 1-hour meal over 5 hours. Have you heard anything different, Jennifer? They just kind of gave us conflicting advice.
I haven't heard anything different,
Okay.
but keep in mind that the Colorado Department of Labor is going to err on the side of being very conservative. So,
Right.
I think as long as there's a reasonable good faith attempt for the employer to be complying and providing the necessary meal periods and rest periods, then I can't imagine there's going to be a complaint or a audit that would result in a fine or a penalty. It's where employers oftentimes fall into the trap of just satisfying employee requests rather than actually making sure that they are doing what the law requires them to do. So in my opinion, I think if somebody's working 11 hours and an 11-hour shift, as long as they get 2 meal periods that are 30 minutes in duration each, then that would be okay, even though the Colorado Department of Labor is saying, well, we think you should give them an hour each. They also do allow 30-minute meal periods. Just omitting meal periods, though, would be bad.
Right. Great. All right. Thanks. The next one is, will the exempt salary rise again in 2022? So exempt means that, an employee has met certain classifications, so they're exempt from overtime. Currently, if you have an employee that is in exempt status, the minimum their salary can be is $40,500. Starting in January 1st, 2022, which I hate to break the news, is only 29 weeks away. The exempt salary in Colorado is going to raise to $45,000. And it goes up after that, tapping out at $55,000 in 2024. The next question we had is, we've noticed the non-exempt remote employees are responding to emails outside of normal business hours. Do we have to pay for this time? Yes, the COMPS is very specific. Their definition of time worked is very expansive. It includes any time during which an employee is performing labor or services for the benefit of the employer. It's really recommended that employers adopt policy that prohibit off the clock work and require approval for overtime. While an employee may still pay for time work, despite these policies in place, they can be used for grounds, for discipline. We hear that a lot. They worked unauthorized overtime. You still have to pay the overtime. The board looks at it as disciplinary. Now, there is some nuances in the law. It says anything over a minute. So there's argument of, well, it was only one text, it was only one phone call. Really, what this law is doing is pretty much limiting the ability for non-exempt, which is hourly employees, to be performing outside of work. And we really encourage to limit that as much as possible. So until there's case law on what that 1 minute is, not sure if just one text and one email is going to be okay. And another question we've got is, do exempt employees need to track time? Because of all these different laws, we've all kind of known that, these exempt employees are paid on a salary basis and they're not entitled to overtime. And the COMPS order did not address this. There's no legal mandate under there that you need for for exempt employees to track time. But, there may be other reasons that, you wish to have certain exempt employees track time, which is like job costing, payroll records, things like that. So that is still right now up to the employer if you want exempt employees to track time. And I'm going to let Jennifer take this one. This is always a hot question, so I'm going to let her take this one over.
Okay. So the question is, do we have to pay employees for drive time to or from a meeting or training held at an off-site location other than a corporate headquarters location or their regular office location? So time worked under the law means time during which an employee is performing labor or services for the benefit of an employer, including all time he or she is suffered or permitted to work, whether or not required to do so. So if an employee is spending time driving to an off-site location to complete a training or to go to a meeting, then they are doing that for the benefit of an employer, and therefore it's generally considered to be paid time. However, time spent that is a normal commute at the beginning or end of a workday is not necessary to be compensated. So the way that this practically out is, say, for example, an employee routinely drives 15 miles to their routine workplace location, wherever that may be, if it's an office, if it's a project, whatever it is. That under the law does not need to be compensated, that routine trip to work and from work. So if you have a situation where you're asking them, okay, we don't want you to go to your normal location, we want you to go to this location for training, or we want to go to this new location. What I generally recommend to clients is, if it's the same distance, if it's not, like a different, a totally different situation where normally they would drive 15 miles, but today you're having them drive 2 hours. If it's essentially equivalent, then in my opinion, that is still considered normal commute time, and that would not be compensable. But if the location, as I said, was a 2-hour drive or was different than their normal commute, then I generally recommend the employer pay the difference between what the normal commute would be and what the offsite location commute would be. So that's typically what I recommend.
Hey, Becky, you're still muted. We can't hear you.
I do that all the time. Everybody's used to that. Great. Does anybody have any other questions on comp before we jump into COVID? Great. So these are very general questions that we get all the time. And like we said, this is what we know as of now. So the first question is, can employers ask about an employee's vaccination status? Yes, you can ask about their vaccination status. And you can ask them whether they've received, the COVID vaccine. It's not considered a disability inquiry under the ADA. So they've clarified for that. But the big thing is employers really should be mindful of asking any follow-up questions or requiring documentation that could reveal a disability or confidential medical information. Vaccination records are confidential if they provide it to you. They're medical records, and they should be retained separate from the employee file in a secure location. The big one is, can employers require vaccination? Well, some employers have adopted a mandatory vaccination policy. You really need to be prepared to address religious and disability accommodations as well as general objections. We strongly encourage that you enlist the help of Jennifer if you are going to write a mandatory vaccination policy. Do not do that on your own. It's something, we strongly recommend that you don't do it on your own. Employers can choose to adopt a policy that encourages or incentivizes the vaccine, versus making it a condition of employment. But reasonable accommodation for unvaccinated employees can be wearing a mask, social distancing, wearing a modified shift, getting periodic tests for COVID, being given the opportunity to telework or accept a reassignment. So this is really going to be your decision, and you just kind of need to decide what your culture is and what the path is that you want to move forward. The next question is, how should employees communicate a vaccination policy during recruitment? This is really important. What they have said is you need to provide as much advance notice as possible to applicants regarding your company policy. So employers need to start considering putting information in their job advertisement. As far as applicants, you cannot ask for proof of vaccination only until a job offer has been extended. So you want to be very careful on that. And then what is the process if an employee has COVID going forward? Once again, this is going to be, there's resources out there. We're going to provide you guidance, but once again, you want to, discuss this among the ownership, the stakeholders, and make sure that this, whatever you've determined, that it is consistently applied moving forward. So you want to remember that, you need to maintain safe workplaces. OSHA requires that. There's still local public health orders and, PH leave for employees. The good news is, the fully vaccinated people generally do not have to quarantine if they've had a known exposure to COVID, unless they're showing symptoms. Now, the CDC recommends, and that's the word, recommends, that employers, should not require a sick employee to provide a negative COVID test result or a health provider's note to return to work. And that's just a recommendation. Employees with COVID who have stayed home can stop isolation and return when they've met one of several criteria that the CDC has updated on their website. So that's kind of where we're at right now on the COVID. Do we have any questions about COVID?
And Becky, while you're waiting for questions, I was just going to chime in with an anecdote about a client matter that I had last week involving a mandatory vaccination policy. So I concur with Becky's advice that before a company adopts a mandatory policy, that it is a really good idea to consult with HR and legal about it, because there are a variety of complaints that are coming from employees about it, as well as there's current pending lawsuits that have been filed. So essentially what my client went through, their healthcare facility, and they actually treat seniors, which is a very vulnerable population with respect to COVID-19. And so the client, we worked together to craft a mandatory vaccination policy for staff. They picked a going forward date. July 1 was the date. We communicated it to employees in April, so gave them advance notice. As of July 1, all staff needs to be vaccinated, or you're not going to be allowed in the workplace. And naturally, as we all know, the COVID vaccination process and vaccinations generally have objections by folks, and that's a personal objection. In addition to what Becky mentioned, there could be disability or religious objections. But if it's just a personal objection to vaccinations generally, or specifically here with COVID-19, the fact that the vaccinations from Pfizer and Moderna and Johnson & Johnson were approved through an emergency use authorization process, meaning they were approved quickly. Obviously, they were approved in December of 2020 when they were created over the past few months. And so it's not the normal process, right, to get a vaccination approved. It's a faster process, an emergency process. But in any event, the lawsuits that are cropping up are challenging mandatory vaccination policies, basically saying that because these vaccinations were approved through the emergency use process, there is a constitutional question involving whether or not this is akin to human experimentation. And so these are the cases that are cropping up. There's 3 that I know of right now, one in Texas, one in New Mexico, and one in California. I don't imagine that these are going to come down in favor of the employee groups that have brought them, just because of the unique situation we're in a pandemic and the emergency, the public health emergency in effect. But you may have employees that are citing to these lawsuits, and of course employees can go to various websites and get a lot of information that they perceive to be as fact, and they can bring those up to employers. So just keep in mind, if you have employees that are objecting to a vaccination policy, or we're happy to help you if that comes up. So basically in that situation, my client had 9 employees that were objecting to the policy, and they were threatening to sue. And so we just had to have a lot of discussions and strategies about how to communicate why the company was adopting a mandatory vaccination policy. And then I prepared a memo that they could send out to all staff to further explain why this policy was being adopted by the company, the due diligence the company was doing, the reasons why, and then some additional information about all these kind of arguments that are out there in the public arena about why mandatory vaccination is somehow unconstitutional. So that's a little anecdote. I don't know if that helps or creates more muddiness, but I do agree with Becky's recommendation. If you're going to adopt one, make sure you consult with HR or legal to help you wade through that, because it's almost a guarantee you're going to have an objection from at least one employee.
Great. Thanks, Jennifer. All right, we're just going to move on to some general HR questions.
Becky, we did have a question.
Okay.
I'm going to jump back a little bit to COMPS. A question came in regards to COMPS. So what if the employee starts their day at the offsite training and then has to go to work at their normal location. Do we let them stay clocked in when they leave corporate and drive to their normal location to work the rest of their shift? I would say yes.
I agree.
Okay.
If they are hourly, non-exempt, then yes, they should be paid for that.
Okay. And then a question for the PHE leave. Do we have to pay the employee if they are just quarantined for the full 80 hours? And I guess that would depend on whether or not the employee was full-time, and however many hours they're eligible for. But if they are full-time, then yes, you need to pay for whatever time is missed for those COVID reasons. Anything else I'm missing?
No.
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 Okay. And I guess if they haven't used any of the PHE hours since January of 2021.
Right.
Okay.
Yep.
Okay.
Great. Just a couple general HR questions. We had somebody ask, do you have an essentials for all businesses list of documents we should have on file in the office and at each location? Yes, our members do have access to a ton of tools and resources, standard policies, posters, recruiting materials. So, if you're interested in a membership, please, ask us. We have 2 different levels that kind of can fit everybody's size. So, and then we just kind of want to, once again, kind of address the employee handbook. Employee handbooks are really a priority right now. I know that they're not required, but in essence, in our minds, they are required. They're going to help protect you. They're going to help set expectations with employees, ensure that you're in compliance with all the laws. And the big thing is once you create a handbook, and I think the step that's missing is once the handbook is updated, you really need to educate your managers. Your managers are your frontline defense. So it's almost like, they need to almost know everything in the handbook forward and backwards as much as they can, or be able to access it easy if they have a question on a decision. That's really where the impact of the employee handbook happens, because then the manager is being consistent. And we all know that's where the majority of the complaints that maybe, we may consider trivial or whatever really comes from people feeling that they are not being treated fair, that someone else has had an advantage. So we really encourage everybody to kind of take that next step and get the handbook updated, and then make sure that you educate your managers and they understand it, have an actual training. So any more questions, Teresa?
Yes, we had one other question come in. The question is, if an employee used the FFCRA leave last year, are they eligible for the PHE leave this year? And my answer was yes, that it basically starts fresh as of January 1, 2021.
Yeah, and to clarify, the FFCRA was federal, and
Yes.
PHE is state. So that's the difference between the two.
Okay. That's
Great.
it.
Well, we're going to wrap it up. We're going to be sending out our newsletter here shortly. And I want to end with some great news. The Colorado legislature session has ended. Yes. And there has not been any additional employment law that I've been able to find yet that they passed. So it'll give us all kind of a breather to get caught up on these this year. But the one bill that got quite far, although it didn't pass, was about sexual harassment. I really encourage you to read our newsletter. That's another thing that, as you're thinking about setting standards, it's really strongly encouraged now, because I can see this bill being reintroduced again, is to have annual sexual harassment training. If you aren't doing it now, I would start. Once again, it just helps with the culture and puts another layer of protection there. So, well, unless anybody else has any other questions, Jennifer, Teresa, do you have any more input?
No, I don't.
Awesome. Well, thank you again so much for your time. We'll see you in August. There's going to be some exciting type of, like I said, some creative things we're going to do. And we'll see you then. And everyone have a great summer. And you know we're here. If you need us, reach out. Have a great day.